Please be seated. We'll hear argument in case number 240273, Cerna versus Pearland Urb.
May it please the court, Mr. Terrazada will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
Good morning, Your Honors. May it please the court. In this motion to compel arbitration case, the transcript of the trial court's hearing gives us some insight on what the court did. Of course, the order is general, like most district court orders, deny or grant. But what the court did was ask pointed, short questions that every jurist and most advocates do when a client comes to you and says, I have a breach of contract case. They say, where's your contract? What's the provision you want to use to enforce or to use to defend against? That's the proper approach to these cases. Let's do contract law analysis. And the court did it correctly, asked why an August release would apply to a next 3 months later visit. We'll get more into that in detail. But the Court of Appeals in reversing the trial court did none of that. There is no trial, there's no contract analysis at all. The same stuff we always do, contract 101. Offer, acceptance, mutual assent, intent, look at the document. None of that is there. Why? Because of the deference to arbitration. The pull, the gravitational pull of the delegation clause has just confused, I think, the court and says, we're not even going to consider whether this contract applies to this instance. We're just going to see a contract and we're going to enforce the delegation clause.
Well, were they depending upon this being a matter of the scope rather than the existence of the agreement? Is that what?
That's what the court says.
And so, do you disagree with that?
Yes.
And could you explain that?
Scope, of course, and I think it's unfortunate that we have to sort of go back and look at the history of arbitration in the last 20 years since Circuit City and before.
Not for my question. I'm really just asking about this issue between scope and existence.
I think scope says, what does this contract apply to? And it is. I will be candid with you, Your Honor. The words matter, and the analysis is a bit confusing. But the courts have said contract formation is different than contract validity, right? Those words are almost insufficient. They still don't answer your question. I don't think they do. But I think we can all agree that if I come to you with a contract, like the trial court did, and said, I have this contract for this lease of oil and gas or whatever, services, and you say, but wait a minute, this is 3 years old. How does it apply to today's lease or today's service? Those are the kinds of questions we would ask.
So when contracts don't establish and express provision for their duration, ordinarily the law implies duration of a reasonable time to accomplish the goal.
Well,
and so and I assume that you would have this argument if the plaintiff had left the facility and gone to another facility that afternoon?
that I would
the
have.
next day?
You mean
would
that
you still say no arbitration clause, no scope issue, it's an existence issue?
Yes.
And so the agreement says that it covers anything that may occur in, about, or near the address on South Sam Houston, or any other premises owned or operated by Urban Air wherever located. So does that include? Does that show that there's some reasonable amount of time that this agreement's going to apply?
I think you're right on. You put your finger obviously on the issues, and if we lost, we should win. That's obviously our position. But if we lost on that analysis, an analysis of durational clause, reasonableness, but we didn't lose on that issue. And the Court of Appeals said, I see a delegation clause, we're going to enforce it. We don't know whether, maybe it did. Maybe the court implicitly ruled that way or thought about it that way. But surely a clause, and this is the interesting part of the case. If we're looking at an arbitration clause within one agreement, then we would not be able to look at the pre-injury release aspect of it, because that's for the arbitrator. But now that we're looking at whether the contract is effective or even entered into, I think then we have to decide, well, when we're making the decision about the durational clause, what are we thinking about? Your analysis is, well, did she go the next day or 6 months? To me, I think it should enlighten or color the court's analysis on the durational clause, that a party is releasing a lot of claims, not the arbitration part. So it's a little nuanced difference.
Did your client pay the second time?
Yes, and I think that's key, Your Honor. I think the durational clause analysis and the reasonableness of it, don't we take into account, well, this was not a membership. I think if she had paid for a year, I don't think we would be here. I think we would lose that argument.
So that suggests another contract because there's additional consideration being provided.
I'm sorry, Your Honor?
That suggests a separate contract because you're paying.
That's
the second
right,
time.
and that's right. And that brings up another point that I don't think the briefs really delve into, is that this is not a one contract case. I have a feeling they might get up, or the court on its own may say, well, look, Coinbase has this language where it says, we're dealing with 2 contracts here, this is one contract. That is not correct for several reasons. But we do have a second contract.
What do we know exactly about why she didn't sign a similar agreement the second time?
Yes, I do not know.
We don't know anything about
I don't know. I don't even know, candidly, to Justice Busby's question, I don't even know if she paid. I don't know if it was a birthday party. I don't know if, when my kids were younger, we would go to these events, and it's just a bunch of people walking.
We've all been there.
Yeah, and so I don't have an answer to that question. The record is silent on it. But the point I wanted to make, and this is important, I think, from our perspective, is we do have a contract. We paid, presumably. There was some consideration to get in the second time. Now, what are the terms of that deal, that contract?
Well, it could be an unwritten contract.
It could be an unwritten contract. I think sometimes it's not Penzo versus Texaco, but it's a deal. I let you in, I get to use your.
Is it a novation? In other words, additional compensation for additional performance, does that negate the existence of the written agreement to the extent it's no longer applicable?
You mean a revocation or novation?
Either. I mean, either. I think you're saying innovation because it supersedes the earlier contract.
I like that approach. Here's the problem. There is nothing in the record or even in their contract that says, the record really, that says either revocation or novation that somehow alludes back to this broad language that you're alluding to. And the problem with, if I may address your issue, Justice Bland, is the Court of Appeals has created arbitration in perpetuity. Why would it be 90 days? Why wouldn't it be 20 years? Because as long as the parties had some deal, what does it matter if it's 1 day, 90 days, or for that matter, the minor grows up, takes his kid there, and Urban Air says, you have an arbitration agreement and it is broad as daylight.
So I guess that the answer to that is the law doesn't provide for an infinite amount of time when there's not a duration clause. It just provides for a reasonable time. And so what we're trying to decide in this case is, does a court decide what a reasonable time is because there's a new set of performance under the contract, they say, or a brand new contract, you say? Or does an arbitrator decide that because reasonable time is a term of the contract that goes to the scope of the particular agreement? And without even ever looking at the later transaction.
I think everything you're saying is this is an all full disclosure. This is a bit of a circular case, right? It's interesting, it's basic, but it can be that. Here's what I would say the answer or the response to that is. I have heard oral argument this morning, and we are all now originalists. We have to all admit this now, right? As hard as it is for many of us. And when you go to Section 2 of the FAA, it says, the Section 2 says, pardon me, Section 2 says, a controversy thereafter arising out of such contract or transaction. If those words were as broad as the Court of Appeals, in this case, ascribes to them, even though it didn't obviously address it specifically, then Coinbase is wrong. Because in Coinbase, they had a transaction, they had broad language, and the court says no. And I think that's the point I would like.
But in Coinbase, there were two contracts, right? One with arbitration provisions and then a later one without. And that was for the court to decide.
And that's your
I think we have two contracts.
Whether this agreement covers one visit or infinite numbers of visits is an issue, is that a question of the scope of the agreement that they have invoked?
Obviously, we think it's a formation issue.
Formation.
Could it be both? Why couldn't it be both? I mean, it could be that, I mean, their argument is that it covers, your argument is, well, there was a separate contract that was not a written contract, but that's not unusual. We have unwritten contracts all the time where, you know, performance for performance, and, you know, you accept by performing. And so why couldn't it be both a question of scope and a question of formation? And so that then the court would decide the formation question. And if we say, well, there wasn't a second contract formed, if the court said that, then it goes to arbitration to determine the scope of the first contract.
I think this case can be framed in many different ways. What I would say, and that could very well be it. I don't think it should be that way, and here's why.
Well, it seems like you win, so why wouldn't it be that, under that approach, so why wouldn't it be that way?
Because you're saying that it would go to the arbitrator.
No, it would go to the court first to decide whether there was a second contract.
Well, yes, of course. Yes, I do agree with that. And I do agree with that. And I don't think there's any dispute, really, that unless we get into, it's not in the record, but I don't think there's any dispute because they clearly answered the trial court when they said there's no membership, there was no like annual membership or long-term membership. But those are reasonable inferences the court can make is that clearly she paid, she got in, that's all for acceptance, and there may be some terms on the walls that say, you know, I don't know, don't jump 30 feet high, etc. That's a contract. And that contract, by the way, does not have, obviously it's not written, so it couldn't even have an arbitration clause. There's no arbitration analysis there. But importantly, it says, look, this is our new contract. And that contract doesn't have any of the terms that the August release has.
Can't many or maybe all issues of scope be reframed as issues of existence? So you have an agreement to arbitrate, and you know one side says that the scope of this is such that it covers X, and the other side says there is no agreement covering X. Those are the same arguments. You're fighting over the same thing. One of you's calling it scope, one of you's calling existence. How do we untangle that?
Justice Blacklock, I don't have a definitive answer. Obviously, from our perspective, formation. Here's what I would answer it in a different way, or try to do. And I don't have a definitive answer for you. But what I would say is, what happens? So what New Prime? This is Texas U.S. Supreme Court. New Prime, Morgan versus Sundance, and then Coinbase. I think what those three cases say to the trial courts and the courts of appeal and all the state courts is, and they say it, in fact, Morgan says it, stop putting arbitration above contract law. What the court says, look, apply basic contract principles. That's what the court says. I think that's what it's saying. I think what Coinbase is saying, look, don't disfavor arbitration, but apply your contract law. So answering to your question, I think if this were a straightforward, no arbitration was involved, we would look at it a little more detailed, and we would not have this color, this cloud of arbitration over our head, and we would look at what is reasonable.
You wouldn't have the release.
That's
I
right.
mean, that's the more important piece of this contract, whether the form's arbitration or the form's in court. The release language, and it's extremely comprehensive, would be not applicable.
And you're talking about a minor, right, Your Honor?
Correct.
Okay, so I would like to leave the court in my few seconds on that issue. I think that the contract formation issue, and this is important, not to get into the delegation. Delegation is just a clause. I think it has taken a life of its own, unfortunately. But the court has said, stop doing that, just look at contract law. I think that, what you just said, Justice Bland, should inform the court's analysis on the formation issue. That you expect a minor to waive all these rights, and you're expecting them.
Well, it's a minor's
Minor.
authorized guardian
Right.
on behalf of the minor, but
And
yes.
and you expect them to release all these without being clear and definite that this contract applies in the future.
Counsel, Chief Justice Blacklock, could I just one question here, just to make sure I understand your position. So if a parent in Pearland drops the kid off at a gym, and then the parent steps out to go to the nail salon or something like that, but then comes back to pick up the kid, that hypo, either now or when you get back up, kind of just what's the does that hypothetical Pearland parent win or lose?
I think Pearland wins, and I'll elaborate on that when I come back.
I have one question, if I might, before you go down. I agree with you that the Supreme Court's cases are saying, look, it's a contract, treat it as a contract. And so here we have this initial contract, and the issue that comes from it is, does the arbitration, the substantive arbitration, apply only in this case or in all visits until it's revoked or whatever else? And that's just a question of interpreting the contract. You say, okay, well, that's great, but there's the other contract that they entered into in it, in which they say that if there's a question about that, the arbitrator gets to decide it. And under your approach, it seems like that's not really just saying, let's follow contract law. It seems like it's giving a very anti-arbitration, arbitrability of arbitration reading to that independent contract. And I'm not sure what's really left of the promise that the parties made to each other that the scope, arbitrability, or validity of this arbitration agreement will be decided by the arbitrator.
May I answer that quickly, Your Honor, and I'll elaborate further. If I'm understanding your question right, of course it releases the jury waiver and it's got to release.
I'm not talking about that. I'm just talking about whether or not the choice between the two things, what's the scope of this agreement? Does it apply, do all of those things apply only to this visit or to some other visit? When they have the additional promise in which they allow the arbitrator to determine that scope, if that is now what the courts are taking on, we're not just engaging in contractual interpretation, because we're then proceeding into doing the very thing that the parties agreed to allow the arbitrator to do. That's the concern I have about saying that your approach is just following what the U.S. Supreme Court is saying. I think it's going further, but I'd like you to tell me why that's mistaken.
I would say that, yes, I am going that far, and I think there will be mistakes when courts overanalyze or make mistakes in the arbitration, in the contract formation analysis. No doubt about it. The courts
Well,
won't.
you agree this is a valid contract. You agree that it was entered into,
Yes.
it's formed. There's no question about that.
Yes.
The only question then is, how far does it apply to this visit, to all visits, et cetera, et cetera?
That's my only. That's right.
And so then the very first, line says that scope, arbitrability, or validity will be determined by the arbitrator, right?
That's what it says. The scope of it. Right. But then I don't know when. Then when does existence ever come into play? What I would say is this.
Maybe it was fraudulently obtained. Maybe it was something where, the parent withdrew consent, a week after that. Whatever. And that seems to be the exact kind of thing that Coinbase is saying. Look, you have to follow normal contract principles to determine what the parties have agreed to delegate. But if that's not the issue, and the question is this, does this initial contract actually go this far or this far? That's the very thing they have already agreed to allow the arbitrator to decide. I just don't see where, I guess both sides could have an unlimited reach at some point, but I think that there's a pretty good limit to this. You could just let a court decide whether they've agreed to actually allow the arbitrator to do it. I'm not sure where the limit to yours is. It seems like there's no possible way that the arbitrator will ever get to actually decide arbitrability, because you're recharacterizing it as formation and not scope.
I think if they had written a contract that said this contract applies for, and at the transcript, at the hearing, the lawyer surmises, but says maybe a year. Let's take him at his word. Why can't they write that in their contract? Whether it's enforceable, I would obviously litigate that on public policy grounds and so on. But it was their burden to do that. They didn't do that, Your Honor.
Again,
not
a substantive point that could be decided by the arbitrator, surely.
I think then it takes contract formation, other than your very rare.
But that's not a formation point. That's like you could have written this more clearly. If you wanted to extend to multiple visits, then you could have said that. I've never yet seen a contract that comes to this court where if we could go back in time and write it differently, we wouldn't. I mean, no matter which side you're on, right? But anyway,
Fair
I
point.
think that
Fair point.
I've
Thank
gone
you.
enough.
Any further questions? Thank you, counsel. We'll hear from the respondent.
May it please the court, Ms. Tari will present argument for the respondent.
Chief Justice, may it please the court. I believe the argument that was presented to you leaves out a few key points. One of the key points is that the Section 2 of the FAA provides that an arbitration clause is irrevocable until it is revoked under contract or equity, under contract law or equity.
But it would only apply to the scope of whatever the contract is, so it seems like we're back to how long was that contract?
Okay, yes, I agree with you. The contract itself that he agrees existed has a statement in it that says it can only be modified by written agreement. So I would disagree with him that there could potentially be a second contract if she goes into the gym, whether she pays or doesn't pay. There's no evidence in the record that she paid to get in.
Well, there could be a second contract, there just couldn't be a modification of the first contract.
That's
Right.
fair.
And in fact, normally there would be a second contract, because I think that the company requires that generally, right?
The companies generally require them to renew their agreement once a year.
Oh, explain that.
So and what I was going to say was that she may not have paid. She may have told them that she had a valid waiver on file, because that's part of coming into the gym, is that you have a valid waiver on file. And she is bound by what she signed.
Is there any evidence in the record about that's a possibility? Or is there any evidence in the record to say that these last for a year?
There's nothing in the record that says that. But she is bound by what she signed.
But where's that coming from? This is
The
new.
year.
These are just facts that you know that are outside the record?
They're outside the record, right.
So if we're going to be doors the record, then let's go back to the hypothetical Pearland parent. Purely hypothetical, this is not about Ms. Cerna. What would be the legal status of a parent, the hypothetical Pearland parent, who walked into your client's gym, didn't sign on the I doohickey thing and didn't pay the money? What would be the legal status of that person, and would the arbitration agreement have anything to do with that?
If she come,
Should be a
with the
trespasser?
agreement, with the agreement that existed in August, we would allow her to come back in the gym because we're saying that agreement applies later. But if a parent that's not Cerna comes in and never pays, doesn't have an agreement, never pays.
No, I'm sorry, I must have been unclear about this hypothetical Pearland parent. If parent comes in at time 1, pays, does the thing on the I thing, and comes in, then at time 2, that is months later, comes in, does not run the finger over the iPad, and does not pay, the legal status of that hypothetical Pearland parent would be trespasser or something different? Or would you say that?
If she doesn't pay, she's trespasser. If she has a valid agreement on file and she comes in and she pays, then she's an invitee.
And if an agent of your client just said, yeah, come on in, invitee, trespasser,
That's a different issue. I mean,
it's a hypothetical, so what's the
yes.
answer?
Yeah, so if she's invited into the gym by someone who works there, then I would say she's an invitee, whether she paid or not, and whether or not she has an agreement on file.
And sometimes, one parent pays for everyone because it's a birthday party or something. So there are kids and parents who come in that don't pay. And if it's their first time in, what you're saying is that, at least outside the record, the policies and procedures of your client are to require them to sign this form. But if they have been there before, at least within a year, and already signed the form, they can come in, not sign the form, not pay, and they'll be an invitee, but bound by this agreement.
They're an invitee by virtue of the fact that they have a valid waiver on file, and somebody has paid for them to come in through the birthday party charge.
Right.
Yeah, and the names of the birthday party people come, that's included, so there's an email that goes out, so there's a process for that. But the question is, who makes the decision about this? Does the court make the decision, or does the arbitrator make the decision? And
Why can't it be both? So that the arbitrator decides whether the first agreement is still going on. The scope of it includes the second visit, and then the court decides if there's been a second agreement.
so if there's a second agreement and there's no arbitration clause, then if we're not talking about arbitration and there are two contracts, obviously it's the court that decides. So the issue then becomes, if there's an arbitration agreement, who decides? And under the separability doctrine, that the arbitration agreement can stand on its own, and if there is then a delegation clause under Rent-A-Center, which is a U.S. Supreme Court decision, then it must go to the arbitrator.
But
Because
it only, the separability doctrine gets you out from some other defect in some other part of the contract, but it doesn't broaden the scope of the of that contract.
Correct. So, but the court's analysis in Rent-A-Center is, you look for an arbitration clause. Does a valid arbitration clause exist? If one exists, is there a delegation clause? If there's a delegation clause, then the issues of arbitrability go to the arbitrator. If there's no delegation clause, then, the procedural versus the substantive arbitrability issue analysis kind of comes forward. But in this case, there's a valid delegation clause.
Right, and I think everybody agrees that because of that, any questions about the scope of the first agreement would go to the arbitrator. So what I'm asking is, why does that mean that any questions about the formation of the second agreement would go to the arbitrator, if there was one?
I think you have to look at the totality of the interactions by the parties. So if there's an agreement that it's undisputed, there's an agreement on August 30th. So the question is, that agreement that cannot be modified unless it's done in writing, there's been no written revocation, there's been nothing to indicate.
Well, but we've said you can orally modify a no oral modification clause, so I don't think that really helps you.
Okay. Well, I think under the Rent-A-Center analysis, it goes back to, you look to see if there's an arbitration agreement. There is. It's separable from everything else. It's separable from whether or not she came into the gym in November and paid or didn't pay. It's separable. And if there's a delegation clause, it's separable, and it goes to the arbitrator to decide. And that's what she agreed to. She's bound by what she agreed to. She doesn't get to come now and say, well, I was able to sneak into the gym and not pay, and so therefore I don't have to have a release if I get injured and want to sue you.
Why isn't that putting arbitration agreements on a better footing than other contracts? If what you're saying is, well, if you have an arbitration agreement in here, even if you can't even ask the question of whether there's a second agreement that was formed without sending it to the arbitrator in the first case. So it seems like you're disfavoring the second contract there in a way you wouldn't if the question was something other than arbitration.
I appreciate that question. I do feel like the Texas decisions are not exactly in step with the federal decisions. And in Baby Dolls is a good example. In this case, it was used by the Court of Appeals for the analysis, but there is a third prong in the Baby Dolls analysis that is based on the Henry Morgan case, and that was decided in 2009, which was decided before the Rent-A-Center case. So my reading is that third prong, whether an agreement exists at all, goes away because of Rent-A-Center and because of the delegation clause. So then Baby Doll's analysis of one...
So wait, because there's an arbitration agreement, it makes the other agreement go away?
It's separable under the separability doctrine. You can look solely to whether or not there's a valid arbitration agreement. And we've already got a party admission, essentially, that there's a valid arbitration agreement.
If a second contract happens, in its text it says, and no prior arbitration clause shall apply, would you argue that that would still have to go to the arbitrator because the first contract might include that within its scope, or would you say that that's something that now a court would determine whether or not this contract has actually created a new space for the parties? Which one?
I think that's a good question. I would say
Surely
it
it's
goes to
easy,
the
isn't it?
arbitrator. I would
You
say-
think that would go to the arbitrator?
I think it would go to the arbitrator because.
When the parties have a contract that actually says, here's our new relationship?
Well, her position is the second contract can't modify the first contract.
Is that really your position? A second contract cannot modify it?
I think a second contract can modify the first agreement. So I would agree with you that you could modify the terms of the first agreement in a second written agreement. And in that situation, if the parties are arguing over which one is valid, then when you have two separate contracts, I think I would agree that the court could make that decision.
So Chevron filed an amicus brief for us, and in it makes this statement: if the Court of Appeals is correct, according to Chevron, a mundane invoice between two companies having an arbitration provision with a delegation clause may subject to arbitration a later multi-million-dollar contract between the same parties with no arbitration provision. Is that correct? This sort of tail wagging the dog. You've got somebody in a company taking a tiny, insignificant little contract that has an arbitration clause, and then a later really big deal that's carefully lawyered does not include arbitration. Nonetheless, because of that first one, you can sort of sneak it in, tail wag the dog, whatever, and, too bad for you. You shouldn't have let that employee over in Arkansas sign this little consignment thing or something.
I'm sure that with all of their attorneys, they would include a statement in their new agreement that revokes any prior conflicting statements to anything that is in the current agreement.
But if they don't,
that's
you
what
would say
happened.
they'd be bound to arbitrate.
I would say that the arbitrator would get to make the decision on whether or not the prior agreement
Right, which
applies.
means they're bound to arbitrate.
Here's the example that bothers me is, sorry. So like the Six Flags Corporation owns Six Flags Arlington and Six Flags Fiesta, Texas, but two separate properties, two separate subsidiaries. If they were to create an arbitration agreement in the name of Six Flags Corporation, but with separate references to their properties, and I go to Six Flags Arlington, and I sign and it says, my agreement with Six Flags Entertainment Corporation is that I'm going to arbitrate any disputes arising out of injuries, et cetera, related to my time at Six Flags Arlington, okay? Later, I go to Six Flags Fiesta, Texas, and I get injured, and I haven't signed anything, right? Your position would be Six Flags Entertainment Corporation could pull up that Arlington agreement and say, this is a arbitration agreement between us and you. It exists. You got to go to arbitration to find out whether it applies to Six Flags Fiesta, Texas, even though it never mentions it.
I think it
I mean,
depends.
it's that kind of absurd scenario that bothers me about your position.
I understand that either direction, it could be taken too far, but I think it's a matter of contract and it's what the parties agree to. So if Six Flags clearly had in the agreement that all of the Six Flags properties
No, it doesn't.
were parties.
It just
Oh.
says this is agreement between Six Flags Entertainment and you agree to arbitrate and to delegate arbitrability to the arbitrators for any injuries arising out of your time at Fiesta, Texas, or Arlington, Texas, right? But then later, I use it against you and say you got to arbitrate all your claims arising out of your time at Fiesta, Texas, right? Completely different. But it's an agreement between you and me to arbitrate our claims, and the issue is the scope of that agreement. Does it apply to claim? Where clearly on its face, it doesn't apply to claims arising out of Fiesta, Texas. And that's the absurdity, it seems to me, of the position.
I hear you. I think that the issue there would be whether or not that Six Flags Fiesta, Texas is a party to that
Nope.
agreement.
Six Flags Entertainment Corporation,
So
which owns both of them.
So I think the answer is no. I don't think that goes to an arbitrator because I don't think that arbitration agreement applies as between the parties because they would likely sue the Fiesta, Texas.
But the
bar.
court has to make that determination.
And a court would make that determination because there wouldn't be an arbitration clause there. Because the arbitration
Well,
agreement
but
would
the
not
court's
be
the one that's having to determine if the arbitration clause applies, and if it,
Well, is there a contract between the parties? In his
Does it
scenario, there is
exist?
no contract between the two
No,
parties.
there is. There is. I'm suing Six Flags Entertainment Corporation, but I'm suing them for injuries I got at Fiesta, Texas, not at Arlington, Texas. And that's who made me sign the agreement. That's the party. We're both parties to the agreement. It's just that on its face, it clearly doesn't apply to Fiesta, Texas. But still, we'd have to go to an arbitrator to determine that, it sounds like.
If there's an arbitration agreement and you agreed to give the scope, the arbitrator the power to determine scope, yes, it would go to the arbitrator. It doesn't mean.
But if you bothered in that case to bring it to the arbitrator, they would just laugh at you and tell you that you're wrong and you've wasted your money, right? And so most people aren't going to bother with it, I would think.
Under the consumer
That's got to
rules,
be part of the analysis, is that if the hypotheticals imagining frivolous arbitrations, might amount to something, but as a practical matter, we have to assume that people aren't going to just waste their time and money on patently frivolous arguments about the scope of an arbitration agreement.
if you're asking whether or not these agreements squelch a party's right to have a day in court, I disagree. The number of lawsuits speaks to that on these issues. Even for frivolous lawsuits get brought regardless.
And sometimes frivolous defenses get raised in order to increase the cost of litigation and perhaps deter plaintiffs from pursuing their remedies.
Not by our firm.
I understand,
I
but
agree
just
that it's a
generally, you were
possibility, but
saying
not by
that
our firm.
We can't write opinions that only apply for your firm.
Yeah, I understand.
So.
I understand. So the
Just,
consumer.
could you talk about the Baby Dolls decision and why it's reasonable to rely on that decision where there was an express duration clause that required renewal for this case where there is nothing said about the length of the contract?
So in Baby Dolls provides kind of a three-step analysis of looking at the agreement to make the determination. And they look at the validity of the contract as a whole. There's three challenges that Baby Dolls allows, and one is to the validity of the contract as a whole. If it is a challenge to the validity of the contract as a whole, which is what's happening in this case, then under Baby Dolls, that goes to the arbitrator.
But could you address Justice Bland's question having to do with the duration clause? There was a duration clause in Baby Dolls.
And Baby Dolls says that it's a scope issue. Baby Dolls says that duration is a scope issue.
So it had expired already, but it still went to the arbitrator.
That was their decision, correct?
But Baby Dolls didn't have a second contract.
Correct. It had one contract.
Well, I think the argument in that case was there was a continuing relationship between the parties in the case, independent contractor relationship, or some kind of relationship that the agreement governed, which would be, I think, your argument in this case, except that your agreement doesn't talk about whether it's, other than to say that it applies at any location, which might say, well, you can't be in two places at once. So it might say it's not one visit. It may not be much more than one visit, but it's at least a visit at one location and another location. But it's different because you don't have a duration clause.
The agreement actually uses the word premises, which is plural. It's defined as any of the urban locations.
Right, and it expressly says Southwest Freeway and any other locations owned by us.
Correct.
Sort of different than Justice Boyd's Six Flags hypothetical.
So Baby Dolls has that third prong, which I think is not a right reading of the law under Rent-A-Center, that Baby Dolls allows a third challenge of whether or not an agreement exists at all, which is what he's trying to bring in this case.
Well, no, he doesn't contest that there's an agreement. He contests whether the later activity is, that the agreement governs that later activity. And you would say that's scope, and he says that's
He says it's not scope. If you get into whether or not it's a duration issue, Baby Doll says duration is a scope issue, and his client agreed to send that to the arbitrator. The Baby Doll's third prong, though, is whether an agreement exists at all, and it looks at whether or not the party ever signed the contract, whether or not the signer had authority to bind, whether a signer had capacity to assent. Those are the issues that Baby Doll looked at, but they were based on that Henry Morgan case that was decided in 2009, and Rent-A-Center came out in 2010.
You don't think that Coinbase and other recent Supreme Court cases kind of confirm that, though, that is for a court to look at those core contract law questions of whether the parties have really consented to do that? All arbitration is contractual agreement.
So Coinbase has two contracts. I think that's why they made that decision, that the court can look at the two contracts. But Coinbase also says on page 1194 that in cases where parties have agreed to only one contract, and that contract contains an arbitration clause with a delegation clause, then absent a successful challenge to the delegation clause, the courts must send all arbitrability disputes to arbitration. And that follows Rent-A-Center. And what they have not done in this case is to challenge the arbitration clause. They have not challenged the delegation clause. And so under Rent-A-Center and Coinbase, that it should be sent to the arbitrator to decide. We're not saying they don't get their day in court. We're just saying that it's the arbitrator who decides it.
Any further questions?
Yeah, it's just one small thing. Focusing on the provision of the contract that refers to other premises owned or operated by Urban Air, wherever located. How many are there? Does the record tell us how many there are, and which is the farthest, the very farthest one from this Sam Houston Parkway location?
The record does not say how many there are or how far the furthest one is, but there are Urban Airs all over Texas. And most of the major cities have Urban Airs.
Any further questions? Thank you, Ms. Terry.
Thank you.
Mr. Terzada, I believe you have 5 minutes.
Thank you, Your Honors. Justice Young, coming back to your position or your question, the word mutual assent, right? Those are the foundations of contract law. I think those words can be used to favor the arbitration position and our position. You can say mutual assent meant what? What did you agree or did you agree to this contract? Or it can mean, from our position, wait a minute, I only agreed to one contract one time. To Justice Bland's point, this contract, as I said earlier, these cases, usually you go in and you pay consideration. I know it's not in the record, but I don't think they would dispute that because they asked about the membership. You pay one time, you go once. There is no, to follow up on Justice Bland's point, there's no ongoing or successive performance issues.
Does the record indicate whether there's, if you wanted to buy like a year pass, you could do that?
There's nothing in the record, but from the question that was asked by the trial judge and answered by Urban Airs, I'm gathering yes. There's a membership. How long, the length of it is, I do not know. But certainly there is one you can, it seems.
But that might also be relevant to how long this one lasts, if there's another option that lasts longer.
Yes, and before I go to my other points, I do want to stress that point. Look, I would like to win, but at a minimum, I don't think the Court of Appeals did any of this contractual analysis. Right. The Court of Appeals saw the delegation clause, and that's the point Justice Young I would make is that, and Justice Busby pointed to it. We're still basically, if we rule in Urban Air, if this court rules in Urban Air's favor, we do have in perpetuity. Chevron's right. You will go get a contract that's 20 years old and say, that's a transaction. We have a relationship. We're both on the oil and gas field, or we're in the midstream, whatever. And we pull that in. That's an arbitration in perpetuity. To Justice Boyd's point, I think Six Flags is a public company. I don't think Urban Air is, but we can use the example. If Ms. Cerna buys some, or her 401k has some shares in Urban Air 10 years from now and sues them on a shareholder issue, is Urban Air going to say, it says all disputes? I mean,
these are the risks of going towards the record, and we can all come up with a bunch of theme park sort of hypotheticals and everything. But I think that's why so many of us have asked hypothetical questions, but with pretty minute detail in them. Because, and I applaud your courage in disagreeing with Justice Kagan on everybody being originalists now. But we're talking about private law arrangements and then talking about how the Federal Arbitration Act is going to apply over them. And so that's why those kind of minute hypotheticals are important for us so that we can write something, because we can't write something for just you or for just your friend in opposition or for just your respective clients or for anybody else who's a friend of the court who cares about this. But that's why the answers to those things are so important, and what's in the record is going to shape what we're able to say, I would think. And so,
Justice Sullivan, I totally agree, and I think what New Prime, to confirm what you're saying, I think this court, let me be candid with the court. This court and the courts of Kansas and Missouri and Alabama have a better grasp of contract law than federal courts do, because you see it more often and you have your particular industries, to your point. And that's why I think I would like a ruling that says, look, based on Texas contract law, the reasonableness, the scope of these issues. The problem we have today is that the Court of Appeals didn't do any of that. The Court of Appeals saw the delegation clause, and that was the end of the story.
So that you say they saw the delegation clause, but doesn't the delegation clause do really significant work in terms of who decides? So absent a delegation clause, all of this would be decided by the court scope.
Right.
But with the delegation clause, that's the problem, and I think your friend on the other side referred to the Coinbase statement that said, look, if there's a delegation clause, that means that scope goes to the arbitrator.
I agree with what the position. This is a nuanced case. I think the issue is that a delegation clause is just a New Prime, Justice Gorsuch says this. He says, look, it's just a term. It's nothing more. We've given it this gravitational pull. It's just a term in a contract. But what did I just say? In a contract. Maybe this is a philosophical debate.
Its scope is coextensive with that contract, and so Coinbase says, well, that's true. If you have a second contract, it may be different.
Yeah, I think so. And I think Total Energies, I think if that's the case, that's what the court was struggling with, is that you got to look at contracts, the specific contracts. And one last thing, you've got to look at the nexus. If you don't look at the nexus from the dispute to the contract at issue, then we will have what Justice Boyd's position is. It'll be endless. Thank you. That's all I have.
Any further questions? Thank you, Mr. Terrazada. Thank you to all counsel. The case is submitted. That concludes today's arguments, and the marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.